Amitesh Jagroop was a Fijian man who came to Australia on a skilled worker visa in 2003. About 2 years later, he returned to Fiji and secretly married Nileshni Singh, who then came to Australia. One night in 2006, they had an argument about a mobile phone. She left the house and he followed her. During their continued argument, he pushed her over and she struck her head. Instead of obtaining medical assistance for her, he left her there. She later died, and he was convicted of manslaughter by criminal negligence. On his release from prison, unsurprisingly, the Immigration Department reviewed his entitlement to remain in Australia. There was no doubt that he failed the character test for a visa, but there remained a ministerial discretion to allow him to remain based on his connection to Australia. Bear in mind that at this time he'd lived for more than 10 years in Australia. The minister had issued a direction to the department called Direction Number 55, which set out a number of things to be considered when an applicant sought to remain in Australia on discretionary grounds. It had later been updated by other directions, which invested less significance in the amount of time that a person had spent in Australia. Now, the actual legal basis of his challenge is fairly complicated and not all that important for the purpose of this case note. What I can say is that a crucial issue was whether the minister's decision to issue Direction Number 55 was a decision of a legislative character or a decision of an administrative character. Decisions of a legislative character are rule-making decisions, which make a general rule. Decisions of an administrative character apply those rules to individual cases. The thing is that while it's easy enough for me to say that, the line between the two is often very indistinct, particularly in situations like this, where we're talking about a direction that talks about how to apply general rules to individual cases. Justices Kenny and Mortimer, citing a single-judge decision in the federal court, acknowledged that the choice between characterisation of a power as legislative or administrative power has been described as difficult in theory and impossible in practice. This case reminds us not to look for a simple or clear distinction between decisions that are administrative in nature and decisions that are legislative in nature.